Next case on our docket is Ettinger versus Kramer. Each one will have 15 minutes to present their argument, and that includes the argument for today. So there's briefs, there's motions, your 15-minute time will include any response you want to make, whether you're the movement or the respondent to the motion, to make all that time. Initially make all the arguments that you can be proceeding. Appellant will be able to reserve 5 minutes for rebuttal. How long would you like to reserve?
3 minutes, Your Honor.
Thank you. What you'll note is that we'll be working, if you look at the clock over there, when that gets down to 3, that's when your time is up. So please ignore the bottom 5 minutes if you would. And I'll try to let each of you know when you're down to about a minute in your time. The arguments are being recorded, so number 1, we come to the podium. Please make sure you introduce yourself. Secondly, please stay behind the podium so the camera can pick you up. And lastly, please speak loud enough so that we can hear you. I don't think it's going to matter in this case, but if you're referring to any victims or minors or anyone, please refer to my initials rather than their full names. The judge has read your brief and are ready to proceed whenever you are.
Good morning. May it please the court, counsel. My name is Rob Sparks, and I represent the appellant, Stephen A. Ettinger Incorporated Profit Sharing Plan. We're asking this court today to reverse the Summit County Court of Common Pleas 2023 decision dismissing the case. And we're also asking the court to deny the motion to dismiss filed appellees and to grant appellant's motion to substitute Debbie Ettinger for the profit sharing plan as the plaintiff. And I'll address that more a little bit.
Is it appropriate for us to substitute at an appellate level?
I believe it is, Your Honor. The rules, the court has Appellate Rule 29, which allows for substitution of parties. The appellate rules also provide that the civil rules apply unless they're clearly inapplicable. And Rule 17, we would argue, Your Honor, would apply here.
Are there any cases you find that refer to Rule 17 and applying Rule 29, Appellate Rule 29?
No.
That seems to be more, I don't want to call it ministerial in Appellate Rule 29, but more things that from the example they give are clear to ascertain from a simple amount of facts. From a guy hears a death certificate or a state paperwork, there's a new officer hears that. This involves some level of factual finding on it to be made by someone, would it not, on timeliness and other issues for Rule 17?
Timeliness in what way, Your Honor?
And Rule 17 for intervention. I mean, you're referring to, really we should go back, because I understand these other rules were part of an interest and get to be intervention, how we decide who gets to come in and those things. Well,
Your Honor, I don't think that the facts are really in dispute here. It is, on the substitution issue, this is a representative action. And a person can lose, or you can have a situation in representative action where the representative needs to be replaced for any number of reasons, and it happens at all levels of the court, of the process. So Rule 17 would allow that. The facts we have in the record are not really in dispute. In fact, we've put them in there for the court in connection with our motion. And this is an issue that, although we haven't seen it before, is an issue that can certainly happen at any level and does happen at any level of the proceedings in any case. An individual, for whatever reason, there can be a merger, there can be a number of reasons that a shareholder, for example, can lose their shares during the process. And there needs to be some way to address that so that the matter can be heard. And because other individuals, because it is a representative matter, other individuals are depending on those representatives to present the claim.
Counsel, I guess I have 2 questions in regard to that. One, you said they have to be able to substitute the parties. I guess the response from the other side would be, sure, and when you found out, there should have been due diligence in finding out, and when you found out, then that motion should have been made at the trial court level.
Your Honor, we would have loved to have found that out at the trial court level. But we had no proceedings. We had essentially nothing going on in the trial court level that would lead to the discovery of that fact. We weren't doing depositions of any parties. We weren't doing any discovery at the trial court level. We were waiting for a decision. It was only when we got into the mediation process with the court mediator, we got to the very end of that, and before the parties reached any or memorialized any agreement, Goodyear asked for documentation of the ownership of the stock. That's when that was discovered. Had we been involved in litigation actually at the trial court level, I'm sure the issue would have been discovered.
What about, you also analogize this to class action representatives. I can't recall, do you have a case where a class representative was changed at the appellate level other than through death?
I don't believe we have one at the appellate level, Your Honor.
Thank you.
There was some in the brief discussion of whether this is a standing or mootness question at the end of the day. Does that matter to us? Is the result going to be different if it's standing? You argued mootness, would it be different if we decided this was standing?
I believe that there is that argument, Your Honor. I believe it makes a difference. Standing is determined at the beginning of the case. Mr. Ettinger, the profit sharing plan clearly had standing at that time when the case was filed. What has happened since is a mootness issue. Mootness does not result in an automatic dismissal of the case. In fact, the court has the ability, the discretion to grant the substitution of parties so that the issue is not mooted. And that's what we're asking the court to do. Your Honor, let me turn to the trial court's dismissal of the complaint. This, as the court knows, the second time we're here on the same motion to dismiss. It was filed 5 years ago. The last time we were here, this court held that the trial court's initial order, which came 19 months after the motion to dismiss was filed or briefed, was not sufficiently detailed to permit review. On remand, the trial court did not permit any additional briefing or conduct argument on the motion. More than 20 months passed after remand before the new dismissal order was issued. And during that time, during the first 32 months that this case was awaiting a decision on the motion to dismiss, there was a lot of additional information that came out about this case, all of which we presented to the trial court and asked to be added to the complaint as part of our allegations of this matter. That was 2 efforts to do that. Both times that was denied. The primary reason for dismissal by the trial court was a demand futility issue. Rule 23.1 requires a demand to be made upon the company, the board, to prosecute the case, against the company to prosecute the case against the board. But that can be excused if making that demand is futile. And under Ohio law, demand is presumptively futile where reasonable minds can conclude that the directors are antagonistic to the claims, are adversely interested in, or involved in the misconduct alleged. The shareholder has to plead particularized facts to show that futility. And here it's futile demand was for 2 reasons. One, it's presumptively futile because there was a robust public record available before the complaint was filed that allowed appellant to allege particularized facts demonstrating that the director defendants are antagonistic to and actively participated in the G159 tire defect issues. And secondly, that the directors face substantial likelihood of liability due to their failure to fulfill their fiduciary duty as directors.
What are the particularized facts you allege in the complaint?
Please?
What are the particularized facts you allege in the complaint? I recall there was this presentation in 2010 to the board by the attorney about what was going on with the G159 tires. What are the particularized facts are you alleging about individual directors in this case, or any director?
Well, Your Honor, first, we do dispute that a director by director outlining or particularization of facts is required. It's not, there aren't cases that is not a particular requirement of Ohio law.
And you're not necessarily doing it here, but you're saying we don't have to.
Yes,
Is that fair?
that is true, Your Honor. But the particularized facts that we allege them is that there was 20 years worth of knowledge of this defect in the tire. The board, as the court knows, was briefed about this by the Associate General Counsel, the same Associate General Counsel who would later be sanctioned in the Hager case for misconduct. At the time that brief was done, that briefing to the board was made, certainly according to NHTSA and according to what we have alleged in the complaint, Goodyear was already aware of the defect in the tire. And in fact, the documents, the Hager case was resolved in about 2010, and the fact that the documents and the data had been withheld was discovered about a year later. But at the time that the Ms. Oki briefed the board, they had already withheld the data and the crash information in the Hager case.
And the trial court, I understood, basically said, well, we don't know what the sum and substance of that briefing was, so because we don't know, you haven't proved it sufficiently. Is that?
The court did say we do not know the content of that briefing. And we do not, Your Honor. We know what they know. And if, and.
Well, we know what they know, they being what the attorneys for Goodyear did when you're saying.
That is true. We know that the
We
briefing.
don't know what the board know, we know what the attorney do and what they did.
That is true. But we know during those 20 years that this defect was concealed, there was continued violation of the TRED Act, the Motor Vehicle Safety Act. All things that at least two committees comprising the majority of the members of the board are required to ensure their compliance with. This is a monoline company. This is what they do, tires. That's important to them to be able to satisfy those federal regulations. They had a lot of litigation, as the court knows, a lot of personal injuries and death claims, a lot of property damage. They had to hire National Coordinating Counsel to manage all this litigation. It is not a matter that was simply going under the radar. The Hager case, where Goodyear was sanctioned, $2.7 million, a case that went all the way and was argued in front of the United States Supreme Court. That certainly should be known.
And you referenced the one briefing, is that all we know that the board had discussions about this, or we, at least from the records, or do we know that they talked about this on a regular basis when the settlements came up?
About the board talking about the tire issue?
About the 150, 159 lawsuits. And we know you pointed to one example of here was a meeting where they talked about it.
We have that briefing, Your Honor. The general counsel, who had to approve all of the G159 settlements, attended every board meeting. The chairman of the board was Mr. Kramer, who's recently left the board. He was responsible for North American operations during the time when all of this was going on, and he had involvement in it.
He signed off on some agreements, as I recall.
He signed off on agreements, and he would have been briefed on issues by Ms. Oki about the G159 tire.
Counselor, down about a minute, I'll let you know.
Thank you. But then we also had the investigation for 4 years by NHTSA that resulted in a fairly scathing report. And it asked Goodyear to do a recall of the tire. And, Your Honor, they did not. They initially refused to do the recall. And I would submit to the court that there's no clearer confirmation of their antagonism to addressing this issue than when your regulator issues a report like this and says you should recall the tire, a tire they were no longer selling and that were fewer and fewer on the road every year, they still refuse to do a recall or to address that issue.
Thank you, Counselor. You're now into your rebuttal time.
Thank you.
Thank you.
Good morning, Your Honor. May it please the court, my name is Jeffrey Ritz from Jones Day. I'm here today with my colleague Sam Leoy. We represent the defendants in this action, certain current and former members of the board of directors of the Goodyear Tire and Rubber Company. John Fairweather from Browse McDowell is here today on behalf of the nominal defendant, Goodyear. With Mr. Fairweather's permission, I will be presenting on behalf of all defendants for the entirety of our allotted time. This court should either dismiss this appeal or should affirm the judgment below for any of three reasons. First, although this case purports to be a shareholder derivative case, the plaintiff here, the Ettinger profit sharing plan, has not been a Goodyear shareholder for almost 2 years. The plaintiff wasn't a Goodyear shareholder at the time this case went to judgment in the trial court, and the plaintiff wasn't a Goodyear shareholder when it initiated this appeal. Hornbook law says that when a plaintiff in a shareholder derivative case divests itself voluntarily of its shares, it loses standing to sue. That means either this appeal should be dismissed because the plan lacked standing when it filed the notice of appeal, or the judgment below should be affirmed because there's no question that at the time the trial court entered judgment, the plan lacked standing. Second, the judgment also should be affirmed because the plan ignored the requirement of making a pre-suit demand, and the plan has failed to show that a pre-suit demand wasn't required here. Its complaint utterly lacked the particularized facts needed to demonstrate that at least half of the Goodyear board at the time this lawsuit was filed could not have exercised their business judgment in considering a demand. And third, the court should affirm because the verification was deficient under Rule 23.1. Any one of those reasons fully justifies upholding the decision here. I'd like to start with the sale of shares issue. Simply put, this is a shareholder derivative case without a shareholder. The plan voluntarily sold all of its Goodyear shares in June of 2022. That is undisputed, but it was never disclosed to the trial court, even though this case was pending in the trial court for almost a year after the plan sold all of its shares. And it wasn't disclosed to this court until late 2023, almost a year and a half after the sale. The plan's voluntary sale of all of its shares means that it cannot maintain the case.
Counsel, I want to make sure you're not disputing that the issue originally arose during mediation at the appellate level.
It was not brought to the attention of the defendants or to any court until the case was on.
I understand
Yes.
you're arguing, obviously, that it could have been discovered, but
It should have been discovered in the trial court below.
thank you.
This case pended for 9 months in the trial court, and there were significant trial court proceedings after the plan sold all of its shares and lost its standing. My colleague stated in his argument that nothing happened in the trial court after the sale of shares. That wasn't true, Your Honor.
You're also, I think you're also saying, I'm just clarifying, that the plan's like standing at the time the case was dismissed?
Yes, yes, because the plan sold its shares 9 months before that. There were significant proceedings in the trial court after the plan sold all of its shares. The same month that the plan sold its shares, it filed a motion to amend its complaint attaching a verification from the plan's agent stating that it was a shareholder, which apparently was not true. There was extensive litigation on motions to amend, and then the plaintiff's motion to amend its motion to amend. There were discovery proceedings in the Ohio court. The trial court had to hear a motion to quash. There were discovery proceedings in Arizona. A court there had to hear the motion to quash. All of that happened while the plan was not a Goodyear shareholder, and when it filed the notice of appeal here, it wasn't a Goodyear shareholder either.
You argued the question of standing. The Klein case seems to say it's not really standing because standing is what is determined. It's determined at the time it's on file. It's really a question of mootness. Would you agree that it is a question of mootness in this case, or you do stand on the fact that this would be a standing question?
It's both of them. Under fundamental Ohio law, the Ohio Supreme Court has said over and over again that standing requires a concrete personal interest in the case, and that has to happen from the beginning of the case to the end of the case. If you look, for example, at the Supreme Court's Willoughby Hills decision in 1992, it's well settled that the right to appeal can be exercised only by those parties who are able to demonstrate a present interest in the subject matter of the litigation. That's the Ohio Supreme Court there. It's both a standing problem and a mootness problem, Your Honor. Both doctrines can concern jurisdictional defects. If a plaintiff loses its standing during a lawsuit, mootness is a consequence. There are other ways a case can become moot, but it's both, Your Honor.
Why shouldn't we grant the motion for substitution?
For a number of different reasons, Your Honor. As we discussed in our briefing, first of all, this appeal is a nullity. They don't even have standing to ask for substitution. Second, substitution would be pointless. It would do nothing to address or correct the fact that the plan lacked standing at the time judgment was entered below, which is an independent and sufficient basis to affirm the trial court's judgment here. Third, Ohio rules do not permit substitution in this instance. And I would point Your Honors to the Rauch case from the 2nd District in 2016. Very similar circumstances here, squarely holding that substitution is not available to correct a standing defect on appeal. And holding also where the appellant lacked standing at the time the notice of appeal was filed, the appeal must be dismissed. And then fourth, even if substitution theoretically were possible here, and we don't think it's possible under the rules, it wouldn't be warranted here. The request is untimely and inequitable. Simply put, it's sandbagging the trial court. It was never brought to the trial court's attention. There was no motion to substitute made in the trial court. Instead, the plan went on litigating the case as if it were a shareholder when it wasn't. They waited 1.5 years to request substitution. Now, even in cases where the substitution rules apply and could theoretically permit substitution, it has to be requested on a timely basis. And that didn't happen here. And the plan...
Counsel, let me interrupt you too again.
Sure.
I just want to make sure I understand something too. All during this time period that the suit was pending, there was no request for verification of the status of the plaintiff as a shareholder?
The plaintiff submitted with its amended complaint. I mean, there was a verification with the original complaint. There was a verification submitted with the proposed amended complaint, both swearing under oath.
So I'm just wondering why this all came up mediation, because evidently it was said, somebody, I can't remember now, but you or the other side said that Goodyear requested verification of shareholder status.
Yes, that's correct, Your Honor, but frankly, it was the duty of plaintiff's counsel to be sure at every material step in this case that his client had a viable
I'm not
claim.
suggesting
Yeah.
otherwise, I'm just trying to figure out what the.
Yes, it came to light during the mediation, because we asked for it. Let me move on then from the standing sale of shares issue to the demand futility issue, if I may. As to demand futility, the question before the trial court is the same question that's before this court now, and that is, were there particularized facts in the complaint sufficient to show that at least 6 of the 12 members of Goodyear's board are substantially likely to be found by clear and convincing evidence to have done something intentionally to harm the company or with reckless disregard for its interests? The trial court correctly concluded that the answer to that question is no. This court respectfully should do likewise. Demand futility reflects and reinforces foundational principles of Ohio corporation law. It protects the board's exclusive statutory authority to manage the business and affairs of the corporation. A shareholder can't just come in under Ohio law and say, I want to manage this aspect of the board of the company's business. That's exclusively the province of the board. The demand futility rule acknowledges that the board is presumed to operate in good faith. That's why Rule 23.1 requires particularity of pleading. Everyone agrees here that pleading demand futility is not a simple task, and it's not a merely technical requirement. It also accounts for the very, very, very high standard for director liability under Ohio corporation law. Revised Code Section 1701-59E requires clear and convincing evidence of an act intentionally to harm the company or with reckless disregard for its interests. And the trial court wrote an 18-page, careful, well-reasoned opinion laying out why that standard wasn't met here. And the overarching failure here is a failure to plead particularized facts to show that any of the directors ever did anything with a mind to harm the company or with reckless disregard for its interests. There is nothing in the complaint by way of particularized facts of what happened at any board meeting or at any committee meeting. There's nothing about any decisions or actions that were ever taken by any director or any board committee or the board as a whole. There is nothing particularized about any documents or reports that were ever presented to the board or to any board committee. Revised Code 1701-59C says directors are entitled to rely on information they get from management or other directors or outside experts and advisors like accountants or lawyers. But there's nothing in the complaint about any advice or information the board ever received from any of those sources, much less anything suggesting that the board couldn't properly rely on that information. And there's nothing about any directions or instructions that the board ever gave to management about anything. In sum, there's nothing that suggests the likelihood of a clear and convincing showing that any of the directors, much less 6 or more of them, did something to harm the company. The plaintiff has pointed to various events that happened in product liability cases a long time ago, but there aren't any particularized allegations that the board ever made decisions or exercised control over the discovery process in any particular lawsuit. Far less that any member of the board did that with an intent to harm the company or with reckless disregard. The plaintiff has made assertions in the complaint about reports that it says should have been submitted to the government, but here again, there are no particularized facts about any actions the board ever took in that area. There's no allegation, no particularized facts that the board ever told anyone not to submit a report that needed to be submitted, or that it was informed that reports weren't being submitted that should have been submitted. The voluntary recall that happened in 2022, 4 years after this lawsuit was filed, obviously can't say anything about about the directors in 2018 and whether they could consider demand, but there's nothing about those allegations that suggest intent to harm the company by any director. And the insinuations about supposed investigations in the complaint, again, none of those are tied to any director, much less 6 or more of them. The trial court also correctly observed that not only are there no particularized allegations about any of those things, but also most of the things that are alleged in the complaint happened a long, long time ago, right? There are allegations in the complaint about things that happened 10, 15, 20, even 25 years ago. And obviously things that happened well outside the statute of limitations can't be said to create a substantial likelihood of liability under the high standards here. That just buttressed the court's correct conclusion that there was no substantial likelihood here. The third basis for affirmance here is that the complaint was not properly verified. The plaintiff's verification was patently inadequate, and the trial court did not abuse its discretion in concluding otherwise. And on that point, I will rest on our papers unless the court has any questions.
I have a question.
Yes.
Can we look at class action litigation as comparable or analogous to derivative suit?
Not really, Your Honor. Not really. I mean, it's a different rule. It's a different body of law. And so it is not directly analogous. And as the plaintiff has admitted both in its papers and here today, they aren't able to point to any case where after a shareholder voluntarily divested itself of its shares in the trial court that it could come in on appeal and try to ask those sorts of
With the
questions.
class action, one of the critical issues is, did the lack of standing occur prior to the certification of the class action or after the certification of the class action?
Right.
I'm not sure with the derivative suit, does that make a difference?
There isn't that sort of stage in a derivative case, although what happens at the very beginning of a shareholder derivative case is the court has to decide whether the plaintiff has standing to try to seize control of the company's claim in the first place, and that's the demand futility question, and the trial court below, of course, concluded that the shareholder didn't have that right. It didn't have the standing, the ability to speak on behalf of the company, even aside from the fact that it wasn't a shareholder.
And I was just going to say, and I understand that argument. I guess I'm just getting at, in both cases, in regard to class action suits as well as derivative suits, you still have a representative representing the interests of a certain, you don't call it class, but of the shareholders or of a class.
In the derivative suit, attempting to represent
Right.
those interests. As the court concluded here, in fact, it didn't have the right to represent those interests because of the statute gives that right to the board of directors to run the company and not any of thousands of shareholders.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, let me address to the court first off an issue which I didn't address the first go-around was the dismissal for the verification of the original complaint. To be clear, the standard the trial court adopted here in dismissing our complaint for it not being properly verified, which it did not do the first time the case came here. When it went back, it added that on as another basis for the dismissal. But the standard the trial court adopted is one that's more stringent than any other Ohio court that we've seen, that anybody has cited to this court. And it adopts a procedural requirement that can't be fixed by any amendment. That's not simply the way this should work in Ohio. The verification that Mr. Ettinger made here showed, alleged, and it was accurate, that he owned the shares at the time. The allegations were based on personal knowledge and the investigation counsel. The trial court wanted us to, wants to impose the requirement that you lay out what the individual shareholder knows and what was determined as a result of the advice or investigation of counsel. And on the standing and the Rule 23 issues that the court discussed with Mr. Ritz, Mr. Ritz asked the court to look at the Rauch decision, and I think you should. Rauch highlights a number of these issues There, that was a zoning board of appeals that was trying to appeal a decision, and is not authorized to do that under Ohio statute, by Ohio law, I think Supreme Court precedent. And try to substitute a different entity with different statutory rights to take on that appeal. The court said, no, you can't do that. That's not what we're doing here. The allegations of this complaint change not one iota, whether it's the Ettinger profit sharing plan, whether it's Debbie Ettinger, his wife, they own this stock in 5 accounts. Or if it's some shareholder that is not connected or related to either of these. The allegations do not change. That's not what was going to happen in the Roush decision. It is a representative action. We're talking Rule 23.1 versus Rule 23. And there is a difference when it comes to the relief that we're seeking here. On the demand futility, I'd ask the court to look at the McCall and the First Energy cases. The facts that we have alleged here in our complaint are very similar to what was alleged in those 2 cases where demand futility was shown. A very thorough analysis, one by Judge Gwynn, another by the Sixth Circuit in the McCall case, that shows that what is alleged here, not a director by director allegation of every single fact that every director knew, but what the directors as a whole knew and what their obligations were in order to find out, in terms of finding out this information and exercising their fiduciary duty. Thank you, Your Honor.
Thank you. I want to thank both attorneys today for their presentation. The court will take the matter under advisement. We'll issue a decision in due course. That will be mailed to you by the clerk of court support and also be available at the Ohio Supreme Court website.
Thank you.
Again, thank you.